All right, good morning, everyone. I'm going to call to order the Code Enforcement Magistrate hearing for Martin County for August 21st, 2024. It's 9 a.m. And if you'll please rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Hey, be seated. Looking out, I know we've got a long docket, but I'm amazed that we have no audience, which is really kind of interesting. Lots of staff here, though, this morning.
Yes.
So we're going to start right at the top of the docket. And our first case is case number ENF 2024-050-357. Respondent is Michael W. Carlson. And it's a failure to obtain permit. It's a stipulated case, and Officer Counselor, you're gonna present. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So I'll help you God.
I do.
Okay. Whenever you're ready.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Michael W. Carlson, is not present as he has entered into a stipulated agreement. The case concerns the property at 3330 Southeast St. Lucie Boulevard, Stuart, Florida, located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Michael W. Carlson. A copy of the property appraiser record is County's Exhibit 1. On May 13, 2024, I inspected the property. At the time, I observed a tiki hut and concrete slab being built without a permit. At the time I photographed the property, the photographs accurately show what I saw then, and is marked as County's Exhibits 2, 3, and 4, and a screenshot of the permit history of the property is County's Exhibit 5. Exhibit 2. Exhibit 3. And Exhibit 4 from the back, showing the concrete slab. County Exhibit 5 is the permit history for the property, showing no permits for an additional slab and/or an accessory structure. Based upon the investigation, I issued a notice of violation to Michael W. Carlson on May 15, 2024, marked as County Exhibit 6. In the notice of violation, he was cited for the following Martin County Code violation: Section 105.1, Florida Building Code, as adopted by Martin County and General Ordinances, Section 21.1, to obtain a permit for the slab in the tiki hut. In the notice of violation, the respondent was given until June 16, 2024 to correct the violation. It was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on July 31, 2024, and is marked as County Exhibit 7. My signature with today's date. The return receipt was not received in time, so on August 7, 2024, I posted the property. A photo of the posting and the affidavit of posting are County Exhibits 8 and 9. It's posted on the front door, 9 being my posting affidavit. I spoke with the property owner on August 15, 2024. He entered into a stipulated agreement and paid the admin cost of $350. I requested all the county's exhibits be received in the evidence, and based on the testimony and evidence, I request that the respondent, Michael W. Carlson, be ordered to comply with the cited provision of the stipulated agreement by December 1st, 2024, and if not compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. And this concludes my testimony.
All right. And couple questions for you.
Okay?
This is not one of those tikis that is constructed by the Seminole tribe, or?
No, he freely admitted that he's doing it himself.
Okay. All right.
And that's what threw me off first, because when I first took the first picture, I thought maybe this was the company building it.
Mm-hmm.
But that's his personal vehicle, so
All right.
it is a do-it-yourself project.
All right. And the $350 costs, have they been paid?
Yes, sir.
All right. So without objection, I'll accept into evidence the county's exhibits 1 through 9 in this case. And reviewing the stipulation and agreed order, I find that it is appropriate to enter the agreed order based upon compliance on or before December 1st, and the payment of $350 in costs with a fine of $100 per day if the permit is not issued by that time. Okay.
Okay, thank you.
Thank you. Is that you for the day?
That's it for me.
Okay. All right, good morning.
Morning.
All right, Ms. Switzer, if you raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, very good. This case is ENF 2024-020727, and the respondent is Judy K. Cook. What have we got?
Good.
Whenever you're ready.
Okay. My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Judy K. Cook, is not present. This case concerns a property at 4563 Southeast Ontario Drive, Stuart, Florida 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Judy K. Cook. A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 28, 2024, during a sweep, I found a home with overgrowth and a damaged fence. At the time, I photographed the property. The property accurately shows what I saw then and is marked as County's Exhibits 2 through 4. Overgrowth. And then the damaged fence.
Okay.
Based upon the investigation, I issued a notice of violation to Judy K. Cook on March 28, 2024. And the notice of violation is marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 67.201A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code, and Section 21.99, accessory structures, General Ordinances, Martin County Code.
And you want to go just back to the first page, if that's all right?
Sure.
All right, good, thanks.
And in the notice of violation, the respondent was given until April 29, 2024 to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on June 7, 2024, and is marked as County's Exhibit 6. The owner of the property requested more time to repair the fence. Therefore, an amended notice to appear was mailed on July 18, 2024 for today's hearing. The amended notice to appear is marked as County's Exhibit 7. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as County's Exhibits 8 and 9. Posting and the affidavit.
Okay.
Therefore, I went to the property again on August 20th, 2024, and saw the grass had been mowed. However, the damaged fence still remains. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 10. I asked that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Judy K. Cook, be ordered to comply with the cited provisions of the Martin County Code by September 30th, 2024. And if not in compliance by then, required to pay a fine in an amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount upon conclusion of today's hearing. That concludes my testimony.
Okay, and looking out, anybody here on behalf of Judy K. Cook? Seeing no one, without objection, I will accept into evidence the county's exhibits 1 through 10 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before September 30th, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And it is so ordered.
Thank you.
Okay, let's see, the next one, also you, okay, is case number ENF 2024-050259-01, and the respondent is Lloyd Simon.
Yes. My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Lloyd Simon, is not present. This case concerns a property at 6102 Southeast Oakmont Place in Stuart, Florida, 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Lloyd Simon. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay,
On May 21st, 2024, a complaint came into our office with a dirty pool and no power to the home. I inspected the property and found that the pool was not maintained, and I also contacted Florida Power and Light regarding the power. They confirmed that the home has no power. At that time, I photographed the property. The photograph accurately shows what I saw then, as marked as County's Exhibits 2 through 5. So 2 is the back side of the pool. This is just another view.
okay,
This is the aerial of the home in question. If you notice, the 2 on either side are green, or blue. The one in the middle is his and is black. And then 5 is the email from FP&L showing that they do not have power.
okay, and I'm assuming the building is not occupied, right?
It is, according to the association, yes, he is, and I did see him walk across.
Okay, all right. Go ahead and continue, and,
Sure. Based upon an investigation, I issued a notice of violation to Lloyd Simon on June 14, 2024. The notice of violation is marked as County's Exhibit 6. In the notice, I cited the following Martin County Code violation, Section 21.105, Swimming Pools General Ordinances, Martin County Code, and Section 21.221, Electrical Facilities Required General Ordinances, Martin County Code. In the notice of violation, the respondent was given to July 15, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on July 23, 2024, and is marked as County's Exhibit 7. The return receipt was not received. Therefore, I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as Exhibits 8 and 9. Posting. And affidavit of posting.
okay,
No call or letter from the property owner was received within the time allowed. As of August 5th, 2024, we received an email from Florida Power and Light stating that the power had been restored. The email from FP&L is marked as County's Exhibit 10. I went to the property again on August 20th, 2024, and saw that the pool was still dirty. At the time I photographed the property, the photograph accurately shows what I saw then and is marked as County's Exhibits 11 and 12. The pool is still dirty. I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Lloyd Simon, be ordered to comply with the cited provisions of the Martin County Code by September 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing. That concludes my testimony.
all right. Anybody here on behalf of Lloyd Simon? Looking out, seeing no one. Without objection, I'll accept it in evidence. The county's exhibits 1 through 12 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property. In order compliance on or before September 30th, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Thank you. Good morning, Ms. Espiat.
Good morning.
All right, this is case number 2024-050-422-01, and the respondent is MKKM Holdings, LLC. Anybody here on behalf of them? No, doesn't look like it. Okay. Officer Espiat, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, whenever you're ready.
My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, MKKM Holdings, LLC, is not present. This case concerns a property at 2428 Northeast Center Street in Jensen Beach, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is MKKM Holdings, LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On May 16, 2024, I inspected the property. At that time, I observed trash and high grass. At that time, I photographed the property. The photographs accurately show what I saw then and are marked as County's Exhibits 2, 3, and 4. Exhibit 2, you'll see right here between both vehicles on the driveway, there's trash and other items.
Okay.
Exhibit 3, the other side of where that vehicle was, more trash.
All right.
And Exhibit 4, high grass around the edges and more trash. And towards the back, I zoom in for you. You'll see a few piles of trash back there as well.
Okay.
Based upon the investigation, I issued a notice of violation to the owner on May 21st, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation. Section 67-201A, nuisance declared weeds, undergrowth general ordinances, Martin County Code, and Section 67.201B, nuisance declared trash, etc., general ordinances, Martin County Code. In the notice of violation, the respondent was given until June 4th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail on July 23rd, 2024, and is marked as County's Exhibit 6. I did a follow-up inspection on August 6, 2024, and found there was an exterior wall cut and appeared to have new doors being installed. The fence also seemed to have pieces removed or damaged. The follow-up inspection is marked as County's Exhibits 7 through 10. 7 shows these two openings. On the one on the right, you could slightly see that there's a new door there. The fence was here. You could still see in the back there's more trash and more high grass. Number 7 is just a view a little bit further back. Number 9 is the same area as the first inspection, where all the trash is in the driveway.
Yep.
And number 10 is just another view of the high grass on this area. Due to the new violations, I amended both my notice of violation and the notice to appear on August 7th, 2024. In the amended notice of violation, I added the following Martin County Code violations. Section 105.1, permits when required incorporated by Section 21.1 General Ordinances, Martin County Code. And for the fence, Section 21.99, accessory structures, General Ordinances, Martin County Code. The amended notice of violation had a new compliance date of August 19, 2024, and the amended notice to appear had the original hearing date for today, August 21st, 2024. The amended notice of violation and amended notice to appear are marked as county's exhibits 11 and 12. And 11, let me scroll for you so you could see where we added that. And 12 is the notice to appear that was amended. On August 7th, 2024, I posted the property on the Martin County Administrative Building. The affidavit of posting is marked as County's Exhibit 13. I did some research on the property on August 7th, 2024, and I found that there was contact information for the registered agent, and I spoke to him on the phone. He stated he was the owner and the brother of the tenant. I explained to him the violations, and he stated he would get him some help to correct them all. Shortly after, on August 13, 2024, I received a call from a person named Roger who stated he was the tenant and brother of the owner. I explained the violations and told him if he corrected all of the trash and all of the grass, I would give him an extension as far as the permits. I went back to the property again on August 20th, 2024, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and are marked as County's Exhibits 14 through 18. 14, let me zoom in for you. Trash here, and now there's trash also at the entry of the home. 15. You see the high grass, trash, part of the fence is still not there. 16, another view of the trash in the driveway. 17, and 18 is the permit history, just showing that there's no permits applied for since 2015. I request that all of the county's exhibits be received into evidence. On August 20th, 2024, the respondent entered into a stipulation agreement with the county to correct all the violations on or before December 31st, 2024. The respondent has paid a cost in the amount of $350 to the county. This concludes my testimony.
Okay. All right, and you're asking that the exhibits be entered into evidence?
Yes.
All right, so without objection, I'll accept into evidence the county's exhibits 1 through 18 in this case. Based upon the evidence and the stipulation and agreed order in front of me, I find that it is appropriate to find the violations exist on the property and order compliance owner before December 31st, which is what the stipulation does. And I acknowledge that $350 in administrative costs have been paid to the county. Note for the record that the registered agent for MKKM Holdings LLC, George K. Wynn Jr., has executed the agreement, and Ms. Aspiat on behalf of the county. So with that, I will go ahead and enter the agreed order.
Thank you.
Yes, ma'am, thank you. All right. Who we got next? Ms. Brownlee, you going to go?
Yes, sir.
Okay.
As soon as I grab the right paperwork.
All right, so this is case ENF 2023-050-362, and the respondent is the Gordon E. McDonald Life Estate Trust. And anybody here on behalf of the trustee?
The realtor's here.
Okay, all right. This is a request for fine reduction. So we're going to hear from the county first, and then, ma'am, if you have anything you need to tell me, you can come up to this podium, I'll swear you in, and then we'll go from there, okay? All right, so if you're here maybe just to observe, that's fine as well. Ms. Bradley, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, whenever you're ready.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3192 Southeast Hawthorne Street, Stewart, in Martin County, Florida. On September 20th, 2023, an order finding violation was issued by the code enforcement magistrate to Gordon E. McDonald, L.E. Trust, agreement dated 4/8/2008 for Gordon McDonald, and the property appraiser is County's Exhibit 1, showing Mr. McDonald as the owner.
Okay?
Exhibit 2 is the recorded order that was put in place. It was for Section 67.201A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code. Section 91.34A, generally inoperable vehicles, general ordinances, Martin County Code. And 21.99, accessory structures, general ordinances, Martin County Code.
Can we just scroll up a little?
Yes, sir.
Okay.
Compliance was required by October 31st, 2023. On July 15th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $74,600 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation, and they brought the property into compliance and offered to pay $6,668 to resolve the outstanding fines which have accrued. In addition, staff has considered the $66,680 assessed value of the property. So we took 10% of the property value for the fine reduction. And the affidavit of compliance is Exhibit 3, showing that we placed it in compliance. Exhibit 4 was Mr. McDonald's request for the reduction.
Okay, all right.
That concludes my testimony for this.
All right, so let's see, we've got exhibits 1 through 4 in this case. And is it Miss Elsman? Eisman. Okay. Didn't put my glasses back on. Do you have anything you need to add? If you do, come on up to the podium. Can't do it from there, so.
I'd say unless you have any questions in regards to it, she presented it perfectly.
I don't.
fine. Okay.
Okay, I'm good, thank you. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. And based upon the stipulation and agreed order, find that it is appropriate to recommend reduction of this fine to $6,668, reflecting 10% of the assessed value of the property. And note for the record that Gordon McDonald has executed this on behalf of the trust, and Ms. Bradley, you on behalf of the county. So this is a recommended order. It goes to the county commission for consideration. Okay. And let's see, what else have we got? Next one is case number ENF 2023-110605. And the respondent is Nee Lee. And this also is a fine reduction stipulation, agreed order. Whenever you're
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1156 Northeast Terrace Way in Jensen Beach, Florida. On March 20th, 2024, an order finding violation was issued by the Code Enforcement Magistrate to Lee Nee for Section 105.1 permits when required incorporated by Section 21.1 General Ordinances Martin County Code and Section 67.201.b nuisance declared trash, etc., General Ordinances Martin County Code. So Exhibit 1 is the property appraiser, showing Mr. Nee is the owner. Exhibit 2 is the recorded order that was put in place.
Okay.
Compliance was required by April 30th, 2024. On July 18th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $13,300 plus cost in the amount of $575. So the affidavit of compliance is Exhibit 3. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation, and they brought the property into compliance and had offered to pay $1,905 to resolve the outstanding fines which have accrued, which represents 10% of the total fine plus the $575 costs. And that concludes my testimony for this one. Oh, and Exhibit 4, I'm sorry, is the reduction request.
Okay. All right. All right, so anybody here on behalf of Lee Nee? Looking out, seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 4 in the case. Based upon the stipulation and agreed recommended order, find that it is appropriate to reduce the fine from $13,300 plus cost in the amount of $575 to a total of $1,905. Note for the record that Lee Nee has signed the agreement along with Rachel Spradley on behalf of the county. This is an agreed recommended order. It goes to the county commission for final approval.
Yes, sir.
Okay. See what we've got next. All right, Officer Bush, you're going to testify? This is case number ENF 2024-010-600, and the respondent is the Agnes A. Duncombe Trust. And Agnes Duncombe is the trustee. Anybody here on behalf of Ms. Duncombe? Looking out, seeing no one. Ms. Bush, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Agnes A. Duncombe Trust, and Agnes Duncombe Trustee, is not present. This case concerns the property located at 4516 Southeast Geraldine Street in Stuart, Florida, 34997, in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraiser of Martin County, the property owner is Agnes A. Duncombe Trust, Agnes A. Duncombe Trustee. A copy of the property appraiser's record of ownership is County's Exhibit 1. On January 25th, 2024, the property was inspected, and at that time, the property was in violation for interior remodel work being done without any permits. The case was documented, and the property was issued a stop work order. At that time, photographs was taken of the property. The photographs accurately shows what was seen at the property and is marked as County's Exhibits 1 through 9. This is a picture of the front of the property. A side view of the property and the air conditioner that was installed. A picture of the stop work order that was issued. A picture of the debris from the remodel of the interior. More debris in the water heater that was removed from the interior. Electrical work that was completed there. The electrical panel. The installation of the unit. Other electrical. Based upon the investigation, a notice of violation was issued to Agnes A. Duncombe Trust and Agnes A. Duncombe Trustee on February 19, 2024, which is marked as County's Exhibit 10. In the notice, I cited the following Martin County Code violation, Sections 105.1 FBC, permits when required, incorporated by Sections 21.1 General Ordinances of Martin County. In the notice of violation, the respondent was given until March 19th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on April 15, 2024, and is marked as County's Exhibit 11.
Okay.
Additional time was granted, and a notice of an amended hearing was issued by certified mail on July 11, 2024, and is marked as County's Exhibit 12. The return receipt was not received, and the Property and County Administration Building was posted on July 30th, 2024, and an affidavit of posting is marked as County's Exhibit 13. On August 6, 2024, the owner, Agnes Duncombe, entered into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of the Martin County Code by November 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per day for every violation. For each violation, for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350 for the stipulation of agreement, sir.
Okay, anything else?
No, sir, thank you.
Okay, and you're asking that your exhibits be entered into evidence?
Yes, sir.
Okay, so without objection, I'll accept into evidence the county's exhibits 1 through 13 in this case. Based upon the stipulation and agreed order, I'll find that it is appropriate to find that violations do exist on the property, order compliance on or before November 29th, 2024, failing which, fine in the amount of $100 a day will accrue, and note for the record that $350 in administrative cost has been paid to the county. And the respondent, Agnes A. Duncombe, as trustee, has signed on behalf of her trust, and Ms. Bush, you've signed on behalf of the county. I'm going to go ahead and enter the agreed order.
Thank you, Special Magistrate.
Okay, next is the Burghardt case. It's case number ENF 2024-010702. Barbara Burkhardt is the respondent, and this is also a stipulation and agreed order.
Yes, sir. My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Barbara Burkhart, is not present. This case concerned the property at 8605 Southeast Bayberry Terrace in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. The respondent has entered into a stipulation of agreement. And according to the official records of the property appraiser of Martin County, the property owner is Barbara Burkhart. A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 7, 2024, I inspected the property. At that time, I observed inoperable vehicles stored on the property, weeds overgrown, garbage, trash, and debris. I spoke with the owner regarding the violations at the property. At that time, I photographed the property. The photographs accurately shows what I saw then and is marked as County's Exhibits 2 through 12. Exhibit 2 being the front of the property, which displays the address and some of the items that are stored out front, along with some vegetation debris. Exhibit 3 which shows some of the vehicles behind the fence. The grass that's here is actually overgrown. And that's the only way to see it due to this fence here, which is broken, but you still can't take the photo from that area. Also, the boats was inoperable. There are additional photos to show these items. Here's another front view of the property, which will show the 2 trailers and also show the overgrowth of the grass on this side of the property.
All right.
Another view of the property, which also showed that this vehicle is inoperable, along with some other trash and debris on the property. Exhibit 6, another angle of the front view of the property, which shows overgrowth as well as the trailer in the rear. Unfortunately, the photo isn't clear, but that trailer in the rear is inoperable. Exhibit 7 is another view of the front of the property. It's the opposite side, which shows some overgrowth here, as well as some other items in the front.
Okay, and the overgrowth there is along the
The
property?
sidelines of the property, yes, sir.
Got it.
Here's another photo that was taken. This is Exhibit 10. I revisited the property on March 25th, 2024, just to see what progress was made. And it shows where they've actually pulled items that wasn't seen previously out into the open and have a container where they were disposing of that, of the trash and debris. On April 30th, another view that shows that the vehicle is still inoperable. And additional items stored out. One of the RVs was already removed, and there was still one remaining.
It looks like there was at least an attempt at compliance.
Yes, sir. Based upon the investigation, I issued a notice of violation to Barbara Burkhart on May 2nd, 2024, marked as County's Exhibit 13. In the notice, I cited the following Martin County Code violations. Sections 91.34A, generally inoperable vehicles, general ordinances of Martin County Code. Section 67.201.A, weeds, nuisance declared, undergrowth, general ordinances of Martin County Code. Section 67.201B, nuisance declared, trash, etc., general ordinances of Martin County Code. In a notice of violation, the respondent was given until May 22nd, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and the notice of hearing was issued by certified mail on July 11, 2024. The notice is marked as County's Exhibit 14. The return receipt was not received, therefore, the Property and County Administration Building was posted on August 8, 2024. An affidavit of posting is marked as County's Exhibit 15. On August 6, 2024, the owner, Barbara Burkhart, entered into a stipulated agreement. The owner agrees to come into compliance with the cited provisions of Martin County Code by October 31st, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per violation per day until compliance. The owner has also paid the agreed administrative cost of $350. At this time, I am asking that the magistrate accept all the evidence into record.
Okay, so without objection, I'll accept into evidence the county's exhibits 1 through 15 in this case. And looking at the stipulation, find that it is appropriate to find that violations as charged do exist on the property in order compliance on or before October 31st, 2024, failing which a fine in the amount of $100 a day will accrue. And further note for the record that $350 in administrative costs have been paid to the county, and that Barbara Burkhart has executed the agreement on behalf of herself, and Ms. Bush, you have on behalf of the county, and find that it's appropriate to enter the agreed order.
Yes, sir. Thank you.
Okay. Let's see. Got one more case. It's case number ENF 2024-020680, and the respondent is the Mattie Preston estate.
Yes, sir. My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Mattie Preston Estate, is not present. This case concerns the property at 8647 Southeast Anthony Way in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of property appraiser of Martin County, the property owner is Mattie Preston Estate. A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 15, 2024, I inspected the property, and at that time, I observed the property and found the property in violation of open storage of an accumulation of garbage, trash, junk, and debris, installation of sheds with no permit, outdoor appliances, inoperable vehicles, construction equipment, a fence in disrepair. At that time, I photographed the property. The photographs actually shows what I saw then, and is marked as County's Exhibits 2 through 13. Exhibit 1, it shows the fence that's in disrepair. It also shows the tractor or commercial equipment in this area here. Exhibit 3, an additional photo of the rear of the property, which is also overgrown. Exhibit 4, just a closer photo of junk and debris in the rear. Exhibit 5, or Exhibit 6. Is another area of the property where the fence is in disrepair, as well as garbage, trash, junk, and debris in the rear of the property.
Okay. Thank you.
Exhibit 7, I'm sorry.
Are 6 and 7 duplicates? No?
They're just closer views in different angles of the rear of the property, so they're all similar,
All right.
so it's different. Exhibit 8, another side view of the property closer to the front areas of the property, which shows additional garbage, trash, junk, and debris. It also shows an inoperable RV. Exhibit 9 is a closer look of the RV. There's a tarp over the RV, and there's all kind of garbage, trash, junk, and debris, and vegetation debris. A photo of the tire.
Of which vehicle?
That was the white truck that was stored in front of the
Okay,
RV.
I remember
It's
seeing it.
up here somewhere. Other end.
Yep, okay.
Based upon the investigation, I issued a notice of violation to Prasti Matty Estate on May 21st, 2024, marked as County's Exhibit 14. In the notice, I cited the following Martin County Code violations. Section 67.201B, nuisance declared, trash, etc. General ordinances of Martin County Code, Sections G24063, outdoor appliances, Florida Building Code, general ordinances, of the Martin County Code, Sections 91.34A, generally inoperable vehicles, general ordinances of Martin County Code, Sections 3.11, permitted uses land development regulations of Martin County Code, Sections 21.99, accessory structures, general ordinances of Martin County Code. In the notice of violation, the respondent was given until June 11, 2024. To correct the violation, it was informed of the need to contact Martin County Code Enforcement upon doing so.
Okay,
An amended notice of violation was issued July 8, 2024, granting additional time to comply by July 23, 2024, and is marked as County's Exhibit 15. Also mailed with an amended notice of hearing simultaneously by certified mail on July 23, 2024, and is marked as County's Exhibit 16.
okay, go ahead.
The return receipt was not received, and the property and county's administration building was posted on August 7, 2024, and is marked as County's Exhibit 17. I went to the property again on August 20th, on yesterday, and saw that the cited violations had not been corrected. At that time, additional photos was taken of the property. That photos accurately shows what I saw then, and is marked as County's Exhibits 18 through 26. So, because the rear of the property was a little bit blurred, and I was trying to capture a closer picture of it, these are the items that they pulled from the rear of the property. And this was yesterday's photo.
Okay, so that's out by the street?
It is. Unfortunately, as I continue with the photos, many of these things, Waste Management may not even pick up. So the property is still out of compliance, sir.
Okay, and I noticed we really didn't talk about the shed needing a permit. That was in your original, and actually the amended notice of violation.
Yes, sir.
Is that still an issue or no?
No, sir, it has since come into compliance. It should not be on the order.
It's not.
Oh, yes.
It's not, and that's
It
why
came
I'm
into
curious.
compliance, they permitted the shed, sir.
Okay, all right, very good. So we're basically down to the trash, the outdoor appliance storage, the inoperable vehicles, and then
The weeds
the
overgrowth.
fence And yeah, I've got weeds. Well, do I have weeds?
Or trash and debris?
I've got trash and debris.
Yes, sir.
All right. Okay, go ahead. That's fine. Let's run through these photos.
So this is the first photo, Exhibit 18,
Yep.
which shows these items. That's the shed that was permitted.
Okay.
Exhibit 19 is the opposite side of the property. It's a closer look at what was the RV and the garbage, trash, and debris that remains. This is the front, direct front of the property, which shows the door of the property and what's at the property in the front area. The other views were side views and the rear view of the property.
It's 23.
This is a front view of the RV,
That's
just to
the
show that the
remainder of the
engine.
RV?
Yes, sir.
Okay. And 26, okay. All righty.
At this time, I am requesting that all of the county's exhibits be received into evidence, and based on the testimony and evidence, I request that the respondents, Preston Estate, be ordered to comply with the cited provisions of the Martin County Code by September 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day for every violation. Every day, every violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
All right, looking out, anybody here on behalf of the Mattie Preston Estate? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 28 in this case, based upon the evidence in your
26.
testimony.
26.
26. Did I say 8? Okay, 26. I'm looking at it. Okay, so anyway, based upon the evidence in your testimony, I'll find that violations as charged do exist on the property in order compliance on or before September 30th. Let me ask you, do you think that's realistic under the circumstances? The trash and debris, yes. Well, there's no permitting, right?
No, sir.
Just the,
It's just a matter of removing the debris.
yeah, okay, no, I think that's appropriate. So, comply on or before September 30th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Thank you. All right, let's see, we've got a stipulation and agreed order. This is the Houston case. It's case number ENF 2024-040217-01. William J. Houston, or Huston, depending on how he pronounces it. And Ms. Bush, that's also you, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I am a code compliance investigator for Martin County. The respondents, William J. Houston, is not present. This case concerns the property at 8855 Southeast Alabama Place in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. The respondent has entered into a stipulation of agreement, and according to the official records of the property appraiser of Martin County, the property owner is William J. Houston.
Okay. Got it.
On April 9th, 2024, I inspected the property, and at that time, I observed work completed with no permit to include a container and a side door added to the garage. At that time, I photographed the property. The photographs accurately shows what I saw then, and it's marked as County's Exhibits 2 through 3, and a screenshot is marked as County's Exhibit 4. Exhibit 2 shows the front of the property, and this is the container in question. Another view of the property. And there is no door there. There's a door there, but there was no door there before, which has been complied. However, it was in the original notice.
Okay.
Yes, sir.
How did they comply? Get a,
They permitted the door. Yes, sir. And this is a screenshot that was originally showing that there was no door that existed there, which was here. Based upon the investigation, I issued a notice of violation to William J. Houston on April 26, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation: Sections 105.1 FBC permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until May 16, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on June 14, 2024, and is marked as County's Exhibit 6. Additional time was granted, and a notice of amended hearing was issued by certified mail on July 25th, 2024, and is marked as County's Exhibit 7. The return receipt was not received. The property in county administration was posted on August 7, 2024, and is marked as County's Exhibit 8. On August 2nd, 2024, the owner, William J. Houston, entered into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of the Martin County Code by November 29, 2024. If not in compliance by then, be required to pay a fine in the amount of $100 per violation for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350. At this time, I am asking that you
accept into evidence?
accept into evidence.
Okay, thank you. So for clarity, we're basically down to the container that's in the rear side yard of the property, and that it either needs to be permitted or removed.
Yes, sir.
All right, and that's basically what the stipulation says. So without objection, I'll accept into evidence the county's Exhibits 1 through 8 in this case. Based upon that evidence and your testimony in the stipulation, find that the violation as charged does exist on the property, and order compliance on or before November 29th, 2024, failing which a fine in the amount of $100 a day will accrue, and note for the record that $350 in administrative costs have been paid to the county. Also, that William J. Houston has executed the agreement on behalf of himself as owner, and Ms. Bush, you executed on behalf of the county. Find that it's appropriate to enter the agreed order in this case.
Thank you, Special Magistrate.
All right, a couple more. Let's see, we've got another stipulation. This is the Coleman P. McDonough Revocable Trust with Coleman P. McDonough as trustee. It's case number ENF 2024-050743-01. And as I said, it's stipulated, Ms. Bush, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Coleman P. McDonald Revocable Trust, Coleman P. McDonald trustee, is not present. This case concerns the property at 9524 Southeast Cove Point Street in Tequesta, Florida, 33469, in Martin County, Florida. This case was not generated from an anonymous complaint. The respondent has entered into a stipulation of agreement. According to the official records of the property appraiser of Martin County, the property owner is Coleman P. McDonald Revocable Trust, Coleman P. McDonald trustee. A copy of the property appraiser's record of ownership is County's Exhibit 1. On May 30th, 2024, I inspected the property, and at that time, I observed work being completed with no permit to include but not limited to installation of a fence, a retaining wall alteration, paver patio, and also a tiki hut installation. At that time, I photographed the property. The photographs accurately show what I saw then and is marked as County's Exhibits 2 through 8. Exhibit 2. Is a photo of the tiki hut and also the addition to the patio area. Initially, there was no cemented patio there, and they installed this fence here without a permit as well.
Okay, and just so I understand it, there's a canal in between where you are and...
Yes, but they also own this, so
Side
there
of the-
is a canal, but they also own the,
both sides.
yes, sir.
All right.
Here's an additional photo of the rear.
Okay. What am I looking at there?
This is the front side of the property and another area of the fence,
Okay,
which wasn't captured from the rear side. And this is the front of the property.
all right.
Based upon the investigation, I issued a notice of violation to Coleman P. McDonald Revocable Trust, Coleman P. McDonald trustee, on June 4th, 2024, and is marked as County Exhibit 9. In the notice of violation, Sections 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances of Martin County Code was cited. In the notice of violation, the respondent was given until July 19th, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on July 24th, 2024, and is marked as County's Exhibit 10. The return receipt was not received, and the property and county's administration was posted on August 8th, 2024, and an affidavit of posting is marked as County's Exhibit 11. On August 9th, 2024, made contact with Coleman P. McDonald Revocable Trust and Coleman P. McDonald trustee and agreed to enter into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of Martin County Code by November 29th, 2024, and if not in compliance by then, an amount of $100 for every violation for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350.
Okay, and again, you're asking that county's exhibits 1 through 11 be accepted?
Yes, sir.
All right, now the copy I've got does not have Mr. Coleman's signature or yours. Do you have that?
No, sir. The original signed stipulation of agreement was being mailed. It does come from another state. They have submitted the USPS receipt showing that it was mailed already, and also I have the receipt for payment. They have paid for the stipulation of agreement.
All right, so what we'll do is I can still adjudicate this based on receipt of the original document, and then I'll enter the agreed order at that point.
Yes, sir.
Okay, so
Thank
let me
you.
just say, I'll accept into evidence the county's exhibits 1 through 11 in this case. Based upon that evidence, I find it is appropriate to find that violations as charged to exist on the property. Those consisting of the need for permits under Section 105.1 of the Florida Building Code. I do have a question. One of the items that was in your, go back to your notice of violation. Let's see, I saw the paver patio, I saw the tiki hut. What are the pool renovations? I saw the fence.
At this time, the owner has called and stated that no pool renovations was completed. However, upon inspection of the rear of the property, which I have not been allowed to do so, then I cannot agree that the pool had been altered or not because they laid the amount of concrete around the pool. So if
You
you,
don't know whether that's actually been,
he's saying that it has not been.
okay. Let's do this. I don't know that the order, the stipulation, I don't think really includes that per se. Yeah, it just requires permits be issued. And I think I'd like to be a little more specific because there is obvious work that was done. I can't really alter this because I don't have Mr. McDonough in front of
Copy is
us.
still out there.
Yeah, exactly. I think what I'm going to do is just put on the record that as far as the county is concerned, this is for the no permits for the installation of the fence, the installation of the pool deck, the paver patio, the tiki hut. And if the county agrees, we'll remove the pool renovations until you know. I mean, you can charge them, but we just don't know that.
We would have no objection to, in light of the testimony, we have no idea whether anything's been done. We would have no
So-
objection to removing the pool renovations.
So we'll go ahead and do that, and I'm going to find that it is appropriate to find that the violations that we've now discussed do exist on the property, order compliance on or before November 29th, 2024. And also note that if compliance isn't achieved, a fine in the amount of $100 per day is contained within the stipulation, and that the respondent has paid $350 in administrative costs to the county. And I will then suspend approval of this until, or I'll make approval subject to receipt of the original signatures on the document, and then we'll go forward. Okay.
Thank you, sir.
All right. Now, the next case, I don't have an agreed order in front of me. That's a violation case?
It's a repeat violation, Your Honor.
Repeat, okay. Now, I have a recommended order in front of me. Let's see what we've got. All right, so this is case number ENF 2024-070-346-01, and the respondent is George M. Waters, Jr. Anybody here on behalf of Mr. Waters? Looking out, seeing no one. Okay, Ms. Bush, whenever you're ready.
Thank you, sir. My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, George M. Waters, is not present. This case concerns the property at 18211 Southeast Federal Highway in Tequesta, Florida, 33469, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of property appraiser of Martin County, the property owner is George M. Waters, Jr. A copy of the property appraiser's record of ownership is County's Exhibit 1. At the Code Enforcement Magistrate hearing on October 18, 2023, the special magistrate signed an order finding violation to correct the following violations. Sections 91.34A, generally inoperable vehicles, General Ordinances of Martin County Code, Section 67.201A, nuisance declared weeds, undergrowth, General Ordinances of Martin County Code. By November 30th, 2023, the recorded order finding violation is marked as County's Exhibit 2.
Okay.
On November 30th, 2023, an inspection was conducted and violations were corrected, and an affidavit of compliance with accrued fines and costs is marked as County's Exhibit 3.
Can you just expand that a little bit so I can read it more easily? All right, so they came into compliance by the compliance date, but no costs were paid.
No, sir, the administrative costs were not paid, sir.
Okay. All right, go ahead.
On July 16, 2024, I inspected the property, and at that time, on July 24th, the property was inspected, and at that time, I observed extreme overgrowth of the property and an abandoned inoperable vehicle. At that time, I photographed the property. The photographs accurately shows what I saw then, and it's marked as County's Exhibits 4 through 9. And this is a photo of the overgrowth and the abandoned inoperable vehicle.
Is that a lot? Is it a vacant lot or is it a?
No, sir.
There's-
This is the structure here.
Okay, got it. Thank you.
Exhibit 5, an additional photo. Exhibit 6. 7. There's additional photos later that does not include the shadow and of the other side of the vehicle as well. This shows the extreme of the overgrowth that carries on to the rear of the property.
And I'm sorry, the photos show, can I see that the vehicle is inoperable?
In these photos, you can't, however, I went back to the property based on speaking with, okay. Based upon the investigation, I issued a notice of Based upon the investigation, I issued a notice of repeat notice of violation to Mr. George M. Waters Jr. on July 29, 2024, and is marked as County's Exhibit 10, and a notice of repeat hearing of violation to George M. Waters Jr. on July 29, 2024, which is marked as County's Exhibit 11.
So the repeat notice is Exhibit 10. Okay, let's see what we've got there. Okay, go ahead. Down. Effective immediately, yep. Okay. All right, and the next page? Okay.
In the notices, I cited the following Martin County Code violations: Sections 91.34A, generally inoperable vehicles, general ordinances of Martin County Code; Section 67.201A, nuisance declared, weeds, undergrowth, general ordinances of Martin County Code. In the notice of violation, the respondent was to comply immediately and was informed of the need to contact Martin County Code Enforcement upon doing so. Based upon the testimony and evidence, I request that the respondent, George M.J. Waters Jr., be found as a repeat violator and be ordered to comply with the cited provisions of Martin County Code immediately and be required to pay a fine in the amount of $250 per violation per day, starting July 24th, 2024, and every day continuing. The violation continues. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. Actually, I skipped the area where I was supposed to show you the remaining photos.
Okay, we're going to go through them. Not to worry.
This was the affidavit, Exhibit 12, of posting.
Okay, whoops. Got it.
And Exhibit 13 through 16 was yesterday's, well, Exhibit 13 through 15 is August 19th, and then one photo of yesterday, just to prove they didn't comply the day before. This is a photo of one side of the vehicle, where it's overgrown on the car, on the vehicle. This is a close-up photo of the inoperable vehicle, showing the tires are flat.
Okay.
That's another one. And that's the property, yesterday's photo showing that it still remains in the same position.
Moved. Okay. All right. You may have already done this. Asked me to accept into evidence the county's exhibits?
Yes, sir, I did it earlier.
Okay,
Before showing you the exhibits, I'm sorry.
Oh, it's okay. So without objection, and there's no one here on behalf of George M. Waters Jr., right? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 16 in this case and find that it is a repeat violation and order compliance immediately. And also find that it is appropriate to assess a fine of $250 a day beginning on July 24th, 2024, which was the date that it was first observed. And that complies with the county code and Chapter 162 Florida statutes. And note that there is an outstanding amount owed and $575 plus additional costs of $575 to be awarded to the county at this time. So
Thank you, Special Magistrate.
not that that's one thing, that's two separate amounts. Matter of fact, I may just interlineate that just so it's real clear that it's 575 plus 575. Can you go back and show me the case number for the prior case? Good, okay. Case number ENF 2023 070 294. Okay, very good. All right. Okay, let's see, we've got one more thing to attend to, and that's the minutes for the July 17th hearing. I have reviewed those and approved them, and I'll go ahead and execute them. I note for the record that the Minutes have previously been signed by the staff recorder, Jillian Kalane, and by John Colondo on behalf of the county. Okay. I think we're all set. The next hearing is September 18th. Very good. All right, so September 18th here in Chambers, and we will see you all then. We stay.
Your Honor, just so you know,
One more thing?
we have somebody that came in late. His hearing was already, or his case was already heard, so I don't know if you want to address that.
Okay, which case is it?
It was the third one that we heard today, Mr. Lloyd.
All right. Mr. Lloyd. All right, come on up here, Mr. Lloyd. Let me just tell you what we did, and we can go from there. Right there, at the podium, Mr. Lloyd.
Podium.
Right there. Perfect. This was case 2024-050-259-01. And is it, because the county property appraiser changes names back and forth. Is your name Simon Lloyd, or is it Lloyd Simon?
Look, I don't see it here. The reason I came in,
No, answer my question, okay?
my first name is Lloyd, my last name is Simon.
Got it, okay. So, let me just tell you, I haven't even sworn you in at this point. What I did was, based upon the evidence, I found that a violation for the swimming pool does exist on the property, and I ordered you to comply on or before September 30th, 2024, failing which a fine in the amount of $100 per day will accrue. And I also awarded costs in the amount of $575 to be paid to the county, basically at the conclusion of this hearing and upon entry of the order. So I don't know if there's anything that you would contest. The photos pretty much showed the situation, and I know that you've had a period of time where you didn't have electric power to the property, and now you apparently do, which is good, because you can't occupy the property without electric power. And basically, that's what I've already done. Now, you have the right to appeal that order. You have the right to request through the county to come and actually have some sort of rehearing if you want to do that. But the fact is that I've already made the order. You weren't here when you should have been. And so, you know, I don't know that there's anything, I'm not going to change anything today. So, but I wanted to be able to tell you that you have that opportunity, but you need to do it through the county staff. And so I would say work with the county staff to figure out and determine where you go from here, okay? And that's it. So good luck to you. I hope you get it all worked out. Anything further to come before us?
No, Your Honor.
Okay, in that case, we are adjourned.